Corporations, I'm paraphrasing again, but basically that's what it said. Corporations are persons under the 14th Amendment and entitled to equal protection under the law. And it actually says that he was quoting Chief Justice Morrison McWait, who was the Chief Justice of the Supreme Court at that time, in saying that. And I said, is the headnote part of the decision? And he said, no, it's not. It has no legal standing. I said, it contradicts the decision. He said, apparently. I said, does anybody else know this? And he said, I don't know. So I paid my 72 cents and, to make copies of this thing very carefully on the copy machine of the whole decision, and walked down the corner and around the street to the office of an attorney who's an old friend of mine, Jim Whitlow, and said, Jim, I'd like to talk to you about the Santa Clara County versus Southern Pacific Railroad 1886 case. He says, oh, you mean the one where corporations became people? So I laid him out on his conference table, and with a highlighter marked the paragraphs that I just told you about. And I said, read this and this and this. And here's the paragraph at the end of the actual decision. And he goes, well, that's not what I remember from law school. And I said, well, here's probably what you remember. Whip out the head note and say, read this. He goes, oh shit. I said, what do you mean? And he said the head note contradicts the case. And I thought, oh, I've got the keys to the kingdom in here. I've had two people now confirm this. And I said, does that mean that we can kind of blow up corporations now? And he said, I don't know. He said, you really need to talk to a constitutional lawyer. I'm more, wills and property, real estate, and the occasional drunk driving case. Small town lawyer here. But he said, and I said, what is a head note? And he said, a head note is a commentary written by the clerk. He said, back in those days, the clerks actually were paid by the publishing company to write the head notes. That's how they made their living, or how they made an additional income in addition to their salary. On researching this, I found that the clerk of the court was a man by the name of John Chandler Bancroft Davis. He earned $11,000 a year as clerk of the court. At that time, the justices themselves only made $10,000 a year. He was the full-time staff of the Supreme Court there in D.C. all the time. Plus, he was paid by Biddle and Banks, or Banks and Biddle, or whatever the company was that was publishing the book, for writing the head notes. That was the value that he added. And he said, and he said to me, and in fact, when I was in law school, they taught me don't ever rely on head notes because there are sometimes mistakes. And there was a Supreme Court case in 1909 or 1914. Those of you who are law students probably know this better than me. That explicitly ruled that head notes had no legal standing. I mean, this actually became a question before the court appointed. So, anyhow, he told me to go talk to a constitutional lawyer. I said, who? And he said, well, Deb Markowitz seems to know what's going on with the Constitution. I have a lot of respect for her. She was the State Attorney General at the time. Now, I didn't know Deb, although we had friends in common, but I'd had her sign out in front of my house when she was running for election the previous year. And one of the cool things about living in a state capital that only has 9,700 people in it is that when you call the Secretary of State's office on the phone and the answer on the other end, Secretary of State's office, you say, can I talk to Deb Markowitz? This is she. And I said, Deb, you don't know me, but we have friends in common in Hal and Shelley Cohen, and I had your sign out in front of my house on Northfield Street, right there on the main drag. Now, oh yeah, I know that house. Thank you. And I said, I wanted to talk to you about the 1886 Santa Clara County versus Southern Pacific Railroad case. And she said, oh, the one where corporations became people? And so I read the thing to her, and her response was very similar to Jim's, a little less obscene, but very, very similar. And so I said, well, what does this mean? Does this mean that, she says, well, it means that the court never ruled that corporations are persons. And I said, what does that mean to us now? And she said, well, there have been at least 30 cases, as I recall, and it turns out that I think there's 34 now, that have quoted the head note, the language in the head notes. And she said the Supreme Court can quote Donald Duck. It doesn't matter. There's sources. If they quote Donald Duck and saying, that in his relationship with Daisy, this is, and therefore such and such is legal now, that becomes the law of the land. You know, in part, this goes back to Marbury versus Madison, which is a whole another wonderful rant, but we don't have time for it tonight, although it's in the book. And so she said, what this means is that the 1886 case wasn't precedent, but the first case that quoted it became the precedent, which it turns out was about 7 or 8 years later. So, I didn't have the keys to the kingdom, but I thought I did. Now, here's where it gets really ironic. So, arguably in 1886, corporations were given the rights of persons. What else was going on at that point in time? In April I'm sorry, wrong one. Where did we go? In November of 1872, Susan B. Anthony went and voted. Bad idea, at least at the time. Actually, I'd say it's a good idea in history, historically. But actually, it was on November 12th. No, it was November 1st that she voted. On November 12th, she wrote a letter saying, all persons are citizens, and no state shall deny or abridge the citizens' rights. 2 days later, she was arrested and charged with voting while female, which was a crime. She didn't have the money to take her case to the Supreme Court, although it was her intention to. You go back and read her letters. But another woman had, whose name was Bradwell. And in 1873, the Supreme Court in Bradwell versus the state of Illinois, another case where a woman had gone in and voted and been arrested for voting while female, ruled specifically, now keep in mind, this is about the time that the same court is giving rights of personhood to corporations. The same court ruled, quote, this is from Bradwell, from the decision, the family institution is repugnant to the idea of a woman adopting a distinct and independent career from that of her husband. So firmly fixed was this sentiment in the founders of the common law that it became a maxim of that system of jurisprudence that a woman has no legal existence separate from her husband, who is regarded as her head and sole representative in the social state. End quote. Talk about an activist court. But, So, then about 10 years later, this fellow by the name of, I'm forgetting his first name, Ferguson. Plessy versus Ferguson. Ferguson was the guy who got thrown off the train, right? Or got arrested on the train. Plessy was the railroad cop, as I recall. Maybe it was the other way. That's the way it was, okay. And he was arrested for walking into the white car on the railroad when he was supposed to stay in the car for African Americans. Plessy versus Ferguson goes before the court. And in that case, John Chandler Bancroft Davis, the court reporter, who wrote the head note in the Santa Clara case, writes in the head note of Plessy versus Ferguson, Plessy, being a passenger between two stations within the state of Louisiana, was assigned by the officer of the railroad company to a coach used for the race to which he belonged, but he insisted upon going into a coach used by the race to which he did not belong. Davis then quotes the 14th Amendment and then says, the object of this amendment was undoubtedly to enforce the absolute equality of the two races before the law, but in the nature of things, it could not have been intended to abolish distinctions based upon color, or to enforce social as distinguished from political equality, or a commingling of the two races upon terms unsatisfactory to either. So the court says, corporations, yeah, they're persons, they got rights, equal protection under the law. African Americans, no. Women, no. And I mean, it's like falling through Alice's looking glass. So, digging into this, what I found, and I also discovered, by the way, that I wasn't the first one to find this, that this had been published in the Vanderbilt Law Review in 1964 in an obscure article that apparently nobody ever read, because I could not, until I was 3/4 of the way through writing this book, nobody brought it to my attention. I couldn't find anyone. That there was a correspondence between Justice Waite and John Chandler Bancroft Davis, the clerk of the court, in which the clerk of the court, and it's on my website, and it's going to be in the next edition of the book, we're actually going to holographically reprint the actual handwritten note. And the text of it's in this book. The clerk of the court says, did I understand you correctly to say that, I'm paraphrasing here, that corporations are persons under the 14th Amendment? And Waite writes back to him saying, I'm not sure exactly what I said, but it doesn't really matter because we didn't address the constitutional issue. But Davis, so then I'm like, okay, so who the hell is this guy Davis who just gave all this power to corporations in the head note? In conspiracy, it turned out, was Stephen Field, who was also in the Supreme Court.